Welcome to Social Science is the Basic podcast with Professor Mohtar Mas'oed.
Good morning. Welcome to the podcast program for Social Sciences the Basic. Today we will discuss about international law and its relevance to international relation studies. Okay. Again, the question is, why should I or shouldn't learn about international law? Okay, that's the main questions. And we will discuss international law by several topics. We have 8 topics. We will discuss the meaning of international law and the sources of international law. And the third, how international law is enforced. And then we will discuss the development of thinking and the experience of international law, and then we will discuss the relations of international relation studies and international law, and then we will discuss substantive topics about ethics and war, law of the sea, and we will finish by discussing Indonesia as an archipelagic state. But first, let me give you some quotes that's very, very important. The first quote says, since the early 1990s, genocide in Rwanda, ethnic conflict in the Balkans, and the 2 Iraq wars have highlighted the urgent need to constrain intra-state and interstate acts of aggression. Okay, so there is a need to talk about international law because so many conflicts, in the world. Second quote is, the world requires more effective forms of conflict prevention and dispute resolution mechanism, but the existing global institutions and legal norms has so far been unable to prevent human misery. Okay, with these two, I would like to emphasize the need for all of us to discuss, to talk about, and to learn and to do research on international law. First, what is international law? International law is a body of principles, customs, and rules recognized as effectively binding obligation by sovereign state in their mutual relation between state and state, nation and nation. There are 3 types of international law. First, public international law. This deals with relationship between sovereign states and international entities such as International Criminal Court. The second is private international law. This kind of law addresses questions of jurisdiction in conflict. If you are an Indonesian citizen, you do business with citizens from other countries, and then you have problem, and then you have a different jurisdiction. Okay, so this is the concern of private international law. The third is supranational law. Okay, this is a set of collective laws that sovereign state voluntarily yield to. This is law created out of negotiated agreement between countries. Okay, so these 3 laws that applies to international relations in the world now. What is the use of international law? Reflecting the purpose of the United Nations, international law has been generally used first to maintain international peace and security, second to develop friendly relations among nations based on respect for the principle of equal rights and self-determination of people. The third, to achieve international cooperation in solving international problems of an economic, social, cultural, or humanitarian character, and in promoting and encouraging respect for human rights. Okay, that's the use of international law. Problem with international law is that this is different from domestic law. There is no specific bodies for making these laws, no specific bodies to enforce the laws. So people ask, is international law really law? To answer that question, we need to think about the several ways about law. In the domestic legal system, we think of law as the rules that the government issues to control the life of its citizens. Those rules are generally created by the legislature, interpreted by the judiciary, and enforced by the executive branch, using the police, if necessary, to force citizens to obey. So what is law for international community if there is no one legislature, there is no judiciary, there is no executive branch or police force? Okay, is it still law? To answer that, we need to use a metaphor. Imagine a school playground with several children at play. The law, quote unquote, is the set playground rules that the teacher tells her student. For example, the teacher might tell them, don't hit your classmate. That's the rule. That's the law. And children would follow this law. Why the children follow this rule? Why the children abide by the law, quote unquote? There are two possible reasons. The first possible reason is that they may follow the rule only because they are afraid of being punished by the teacher. The second possibility is that the children may believe that it is a bad thing to hit their classmate. It's a bad thing to fight your classmate. It's a bad thing to punch your classmate. Okay. So, since it is a bad thing to do, they will follow the teacher's rule. And later they found out that when they follow the teacher, they have more fun playing in this playground. Okay. So, in the first case, the children will obey the rule only if the teacher is there and ready to punish them. This is just like when people on the street, they follow the traffic lights rule only because the police was there. When the policeman was not there, then they might not abide by the law. Okay, that is the first case. In the second case, student will obey the rule even if the teacher is not there. That's the second case is similar to what we see in international law. Certain common understandings between children may make it easier for them to play, make more fun for them to play when they abide the rule. With the same logic, collective agreement on certain rules can often serve the interests of all the members of community. Just as on playground without teacher, in international arena, there is no central authority. Most of the time, however, states will follow the rules they have agreed to follow because it makes this interaction easier, more peaceful for all parties involved, and more useful for their relation. Okay, thus the fact that there is no overall authority to force compliance with the rule does not necessarily mean that there is no law. Okay, international law there, and people, nations, states comply to that, although there is no word police, whatever, although there is no word judiciary to force them to comply. Law still exists in this setting, though it may be practiced and enforced in different ways. That's the issue with the law. You have no central authority in international arena, but still you see that international law applies and people and nation and states comply with that. Now we move to the sources of international law. Unlike the condition within the nation state, in the international arena, like I said, there is no governmental authority, no parliament to make international law the way the domestic legislature does. So where have international law come from? What are the sources? First, the most important source is treaties. Okay, negotiated agreement between countries. These treaties are similar to contract. You abide by contract because you already agreed and you sign it. So in a contract, people give promise. So the state A, state B, exchange the promise. Okay, so promises between states are exchanged, finalized in writing, and signed by the parties to the agreement. States may debate the interpretation. State may debate the implementation of a treaty, but the written provision of a treaty are binding. Treaties can address many different kind of fields. There are many treaties on trade relation, like ASEAN Free Trade Area, or treaties on control of nuclear weapons, such as Nuclear Non-Proliferation Treaty. Okay. Treaties can be either bilateral between two countries or multilateral between many countries. Treaty can have their own rules for enforcement. There is some passage within the agreement. There is a chapter talking about the how to enforce it. The rules concerning how to decide dispute relating to treaties are even found in the treaty themselves. And this is governed by the Vienna Convention on the Law of Treaties. Okay, this is the legal rule that recognized, accepted by many countries. The second source is custom, like domestic law. You have customary international law, but the problem is more difficult to ascertain. A treaty, you have treaty, written document, but custom is not written. That's why sometimes it's very difficult to, is it custom or not custom? Customary international law is created by the actual actions of state or state practice, when they demonstrate that those states believe that acting otherwise would be illegal. Okay, so the practice of countries that the practice abiding by the law, abiding by the custom, abiding by the tradition. Even if the rule of customary international law is not written down, it still binds state, requiring them to follow. One example is about the immunity of ambassador. Since 1,000 years ago, ambassadors from another country were not harm while on their diplomatic mission. They are given protection, even if they represented a country at war with the country they were located in. So you have now the concept diplomatic immunity. Okay, I remember a story about a Japanese diplomat who were still in Washington while Japan and United States just started the war, and they were protected by the international law. Throughout history, many countries has publicly stated that they believe that ambassador should be given this protection. Therefore, today, if a country harmed an ambassador, it would be violating customary international law. This is not the result of treaties, this is just custom, but still countries and state and government abide by the custom. Similarly, throughout modern history, states have acknowledged through their action and their statement that intentionally killing civilians during wartime is illegal in international. This is customary international law. The third source of international law is general principles of law. This law is based on the theory of natural law. The theory of natural law argues that laws are a reflection of the instinctual belief that some acts are right while other acts are wrong. So this is the human instinctual belief that become base of the principle law. The general principle laws recognized by civilized nations are certain legal belief and practice that are common to all developed legal systems. Okay, and the example this is about the good faith. Okay, the concept of the good faith that everyone intend to comply with agreement they make. So people believe that when you make promise, you will keep the promise. Okay, that's the principle of good faith. Courts in many countries will examine whether the parties to a case acted in good faith and take this issue into consideration when deciding a matter. So good faith may be considered a standard international law now. The fourth sources is simple, this is judicial decision. So whenever International Court of Justice or International Criminal Court decided on certain matters, it will become the sources of international law. The fifth source of international law is the works of legal scholars. So scholars who publish their thinking can be source of international law. Of course, this is not so strong, not as strong as treaties, of course, not as strong as the customary law, but still legal scholarship is used by judge that considering a matter in international law. Going back to the issue of the absence of legal enforcer, because we don't have global police to enforce the law, how is international law enforced? A treaty may have incorporated into its own text provision of how to enforce the agreement. But sometimes international law in question is not explicitly written out in a treaty. In that situation, how can this unwritten law be enforced? In practice, there are variety of methods, to enforce the law. States are more likely to fear tactics used by other states, such as reciprocity, collective action, and naming and shaming. First, reciprocity. This is a type of enforcement by which states are assured that if they offend another state, the other state will respond by returning the same behavior. If you hit me, I will hit you. Guarantees of reciprocal reaction encourage states to think twice about which of their action they would like imposed upon them. For example, during a war, one state will refrain from killing the prisoner of another state because it doesn't want the other state to kill its own prisoners. Another example, in a trade dispute, one state will be reluctant to impose high tariff on another state's good because the other state could do the same in return. This is a reciprocal interaction. The second method of enforcement is collective action. Through collective action, several states act together against one state to produce what is usually a positive result. Okay. Remember when Iraq in 1990 invaded Kuwait, but that invasion was opposed by most of states. And other states organized through the United Nations to condemn Iraq and to initiate joint military action to remove Iraq from Kuwait. Okay. This kind of collective action happened several times in international relations. Okay. The third method is name and shame approach. Okay. Most states dislike negative publicity and will actively try to avoid it. So the threat of shaming a state with public statements regarding their offending behavior is often an effective enforcement mechanism. This method is particularly effective in the field of human rights, where states not wanting to intervene directly into the domestic affairs of another state may use media attention to highlight violation of international law. This is the common practice now. So you send media to make a report on the bad behavior of those countries you want to name and shame. Okay. Now we move to the history of international law. International law already practiced 1,000 years ago. There are evidence that two city-states in ancient Mesopotamia already had written treaties. That was about the setting of boundary between the two city-states. Okay, that was 1,000 years ago, even before Christ. Roman Empire already included jus gentium, laws governing the interaction between private Roman citizens and foreigners. The Roman law consisted of natural law, such as basic ideas of fairness, and that still form part of modern international law that we are using today. Increased international trade after the fall of Roman Empire served as a catalyst for developing new rules between states, new codes of conduct, for relation between states. And this formed the basic of international trade and maritime law up to now. Modern interstate law emerged as the modern interstate system was born and was an inseparable part of it. Lawyers serving the interests of powerful government 1,000 years ago helped to establish a doctrine that if states were wholly separate from each other, sovereign over their own territories and people, and equal status to each other, then they could recognize each other and conduct business on the basis of that mutual recognition. This is the theory of sovereignty. Okay, and sovereign state recognize other state as a sovereign. In modern day, that started since the Industrial Revolution, international transaction by 17th century already accumulated many international practices, rules, and treaties, Hugo Grotius compelled them to write his masterpiece, the Jure Belli ac Pacis Libri Tres, on the law of war and peace. And that was considered as the date of the birth of modern international law. Grotius believed that natural law came from an essential universal reason, common to all men. It was derived from principle, not from deity, not from religious teaching. And he proposed two basic axioms. This is come from the natural law. First axiom: all promises or agreement must be kept. Okay, in Latin it's called pacta sunt servanda. Whatever you give promise, you have to keep it. Okay. The second axiom is harming another requires restitution. This is come from natural law, according to Grotius. These two axioms became the basis of modern international law. Grotius saw the difference between what was done versus what ought to be done. In this sense, Grotius is positivist, because he believed that what was done is more important than what ought to be done. Okay, state practice. So state practice resulted in laws. So this is man-made laws versus normative rules, religious moral doctrine. According to Grotius, state practice is more important compared to the normative rule. So this is a positivist approach by the Grotius. So he said something like what is more important than what ought to be. In German we say das Sein, what is more important than das Sollen, what ought to be. Okay, that's the idea. Then we have Treaty of Westphalia, 1648. IR students always remember this year. That was the treaty that ended the 30-year war, and the gathering is in the form of major diplomatic congress with over 100 delegations. And that Treaty of Westphalia resulted in the establishment of state sovereignty as the cornerstone of international order. Introduced the notion of balance of power, interstate aggression to be held by balance of power. Okay, and several points that I will let you to read later when I share this PowerPoint to you. And then League of Nations, founded in 1920 and dissolved in 1946. This is created after World War I as a response to an outcry for rules of warfare to protect civilians and to curb invasion. And the products of League of Nations is established permanent court of international justice, try to avoid state resorting to war, and international labor organization. Also, coming out from the League of Nations is first Geneva Convention dealing with humanitarian relief in wartime, and then several other bodies of international law. League of Nations failed due to many causes. First, it only consists of the victors of World War I. It has also structural weakness that all decisions require unanimity. If one disagrees, that you will not get any agreement. Another weakness is that League of Nations lack of global representation. Many states never joined the League of Nations. Another weakness is that the idea of collective security, because according to the collective security principle, state might have had to act against friendly states in some cases. So states are not happy with that. And the last weakness is that general unwillingness to disarm. So disarmament failed, and that's the weaknesses of the League of Nations. The last is about United Nations, which was founded in 1945. The main reason behind establishing the United Nations was to avoid another world war due to the unimaginable horror and losses suffered during the two horrible world wars. United Nations started with 51 member states and now has almost, might be more, 200 member states. The main objectives are to maintain international peace and security, to promote human rights, to foster social and economic development, to protect the environment, and to provide humanitarian aid. Now we move to the topic of relations of international relations and international law. Let's start with this quotation. Law structures politics and international relations, and politics permit law. The domain of politics and the realm of law are so intermeshed that any attempt to locate the boundary between them would be fruitless. Okay, so politics and law intermesh each other. In early 20th century, IR studies was very legalistic. Relation of international relation and international law during this time was very close. International affairs was assumed to include international legal issues. Back then, analysts did not sharply distinguish IR from international law. IR courses were often about international law and frequently confounded the prescripts of international law with the way states were said to behave in fact. So IR and IL, back then were very closely related. However, when Second World War broke, international law fell into disrepute among IR realist scholars who argued that international legal rules and processes had not operated the way many had hoped. Legal rules failed to contain German and Japanese aggression, and then also legal rules failed to keep international economy from functioning. Remember back then there was a Great Depression and legal rules could not do anything about that. So these two resulted in the humanitarian disasters of Second World War. Since then, for more than 30 years after the end of the war, political science and IR turned its back on international law, focusing its study of IR on the material interest, not the moral one, and observe behavior of state, not only the normative and legal issues. Okay, so since the end of the World War, international law fell into disrepute among IR realist scholars. Why? Because in 1930s, international law and lawyers, according to the IR scholars, underestimated the role of power in the relation between states. German and Japanese and Italian were a strong power and behave as a great power. They don't behave on a moral ground. International law was considered as too legalistic. International law was deluded about the capacity of law to regulate the behavior of state. The behavior of state could not be regulated by international law back then. The third critique of IR scholar is that international law was apolitical. does not include consideration about politics. Indifferent to the great looming concerns of war and peace. Back then, already there was problem with this, and people, saw the war was imminent. But still, international law, the fourth critic by IR scholar is that international law tended to confine the energy to the peripheral issues. Okay, ignored the force dimension, ignored the fact that German and Japanese and Italian use force, not only reason, and that's the critics. Okay. However, in early 1980s, many IR scholars has rediscovered a role for law in interstate relations. Many IR scholars recognize that the post-Second World War order was built not only upon power relationship, but also on negotiated agreement. International legal rules, procedures, and organization are more visible and more effective than at any time since 1945. In the post-Cold War world, that is after 1980s, international law has also undergone change. Let's start with the first change, that is increased number of negotiated agreement. After 1980s, negotiated agreement proliferated tremendously. A century ago, most international law arise from customary laws. Today, most international legal obligations are expressed in treaty form, and that's the result of multilateral treaty-making capacity of international organizations like the United Nations. So, what differentiates international law today with those of yesterday is that now it comes from negotiated agreement. The second change is increasing scope of topics and subjects addressed by treaty law. In late 19th century, most international law defined the rights and responsibility of states towards each other. So in up to late 19th century, international law is public international law. During 20th century, international law increasingly began to address responsibility of state toward individual and non-state actors. That's why you have now many agreements on how to deal with women issues, with environmental issues, with children issues, with labor issues. So not only about the state, but also about individual. Okay, that's the really great change. The third change is about more authority delegated to international court to adjudicate international dispute. The number of international judicial, quasi-judicial, and dispute settlement bodies has grown from just a handful in 1900 to nearly 100 today. Interstate dispute over territory, trade, human rights, environmental protection, intellectual property, labor protection, and criminal matters now may be resolved in international institutions. Now we move to more substantive subject. This is about salient issues. Some of them will be discussed. We will not cover all the salient issues. The first issue is ethics and war. And here we will discuss an author called Hugo Grotius. Grotius views international politics as taking place within international society in which states are bound not only by rules of prudence and expediency, but also by imperatives of morality and law. Grotius introduced constitutional approach to the study of international politics. The approach directs our attention to the rules which constitute and govern political life between sovereign states. One of the principal features of the Grotian tradition in IR study is the conviction that the totality of international relation is subject to the rule of law. Okay, this is the legal approach. Okay. Grotius also teach us about the ethics of war. According to Grotius, war gives rise to two moral questions. First, what are the conditions of a morally justified recourse to war? Okay, war is not good thing. It's not good behavior. It's not good invention. But somehow war happens. So you need to talk about the moral thing here by asking when recourse to war can be morally justified. The second question, what is morally legitimate to do in the course of fighting a war? Grotius answered them by proposing just war theory. First, it's called jus et bellum, okay, justice of war. For the first question, the answer is justice of war theory. For the second question, the answer is justice in war, jus in bellum. Okay, that's the answer for the second question is justice in war theory. What is justice of war then? According to the theory of justice of war, resort to war is justified. You can go to war, okay, if you satisfy this requirement. Okay. Resort to war is justified. First, if the cause is just and the intention is right. Third, if the decision is made and declared by legitimate authority. And fourth, it is done as a last resort if you have no other alternative, no other option, then you can go to war. Fifth, resort to war is justified if there is a reasonable hope for success. If you don't see any success in doing war, don't do that. The last requirement is resort to war is justified if the harm caused by war will be proportionate to the benefit achieved. That's the requirement, the prerequisite. If you go to war, you must satisfy these 6 requirements. The first 3 requirements refer to justice or a decision to go to war. Okay, I decided to go to war. Is it justified or not? And then that was the cause. Is the cause is just? Is the intention is right? Or is it decided by authority, legitimate governmental authority? And the next 3 relate to the consequences of such decision. If you have that kind of decision, is the decision is the last resort? Do you see hope for success? Consider the harm is proportionate. This is the theory of justice of war by Grotius. What is just cause? Like a defense. You can go to war either to defend yourself or to defend others, like your friend. And second, a just cause is that the decision to resort to war must be made and declared in appropriate way. It must be made by the highest authority of the state. The second theory is the justice in war, used in bellum. An act of war, a tactic or a strategy is morally justified if it respects non-combatant immunity. Okay. Second, if the harm it causes will be proportionate to the military aim achieved. Okay. The second clause about the proportionality is not that hard. It's relatively straightforward. You need to be proportional. But the first requirement concerning the non-combatant immunity is more complex. The reason that this is required is that we need to limit the killing and the destruction inherent to war and accord immunity from harm to those who are not involved in the waging of war and therefore do not constitute a legitimate target of war, like the non-combatant, civilian, and the innocent. There are differing views on this. Sometimes it's not easy, to differentiate the combatant and non-combatant. Okay, that's the issue. And up to now, there has been discussion and debate about this issue. Now we move to the salient issues about the law of the sea. Two functions of the sea in the human life: as a medium of communication, medium of transportation. Second, is a vast reservoir of resources, both living and non-living things. Because of the importance of the sea, you need international regulation about this. The fundamental principle governing the law of the sea is that the land dominates the sea, so that the land territorial situation constitutes the starting point for the determination of the maritime rights of the coastal state. In the 17th century, the Portuguese proclaimed huge tract of the high seas as part of their territorial domain. Okay, so Portuguese claimed the sea belonged to them. But these claims was challenged by Hugo Grotius, who elaborated the doctrine of the open seas. According to the doctrine, the ocean, as part of res communis, as part of custom and law, were to be accessible to all nations, but incapable of appropriation. This view prevailed, partly because it accorded with the interests of the North European states, which demanded freedom of the sea for the purposes of exploration and expanding commercial intercourse with the East. Since then, the freedom of high seas became a basic principle of international law. But a coastal state was permitted to appropriate a maritime belt around its coastline as territorial waters or territorial sea and treated as an indivisible part of its domain. Much of the history of the law of the sea has centered on the extent of the territorial sea or the precise location of the dividing line between it and the high seas and other recognized zones. The original stipulation linked the weight of the territorial sea to the ability of the coastal state to dominate it by military means from the confines of its own shore. But the present century witnessed many states try to enlarge maritime belt and subject more of the ocean to their exclusive jurisdiction. Many countries to enlarge their territory by occupying the ocean. The effort of countries to create international law resulted in the United Nations Convention of the Law of the Sea. We use the abbreviation UNCLOS. The UNCLOS became effective from 16 November 1982. Before the convention came into force, there existed a school of thought known as freedom of the seas. This is by Hugo Grotius. This doctrine had first come into operation during the 17th century. According to this doctrine, there were no limits or boundaries set to the aspect of marine business and commercial activities. Over the years and centuries, as technology developed and the needs of the people across the world grew, there emerged a problem. Overexploitation of the sea's resource was immensely felt toward the middle of the 20th century, and many nations started feeling the need to ensure protection of their marine resources. Started with the United States in the 1945, many countries across the world brought under their jurisdiction the natural resources found in their ocean continental shelf. Some of the countries that exercised this power were Argentina, Canada, Indonesia, Chile, Peru, Ecuador, and even countries like Saudi Arabia, Egypt, Ethiopia, and Venezuela. Since the usage of the marine reserve rose even more in 1960s, and since missile launch pads also starting getting based in the oceanic bed, it became imperative that a specific regulation be placed to ensure proper protection and jurisdiction of the marine reserve. In 1967, the Third UN Conference on the Law of the Sea was convened. In this conference, UN members discussed a legal power that could bring about international governance over the oceanic floor and bed. Such a legal power would also ensure that there would not be any problem rising between various countries over the oceanic floor and bed space. The Third United Nations Conference on the Law of the Sea paved the way for the now existing nautical law. The United Nations Convention on the Law of the Sea, as the currently prevailing law of the sea, is binding completely. Even though the convention has 160 member parties, the United States is a country that still not ratified the nautical law. The main reason for the US not sanctioning the law arises mainly because of its disagreement about Part 16 of the Convention. Part 16 of the Convention deals with the aspect of minerals found on the seabed. The International Seabed Authority was established on the basis of this part of the nautical law and called for equitable distribution of the proceeds of such seabed. The US is opposed to this theory, and that's why it has not ratified the convention. Now we move to the topic, this is the last topic, is Indonesia and the United Nations Convention of the Law of the Sea. Indonesia is the largest archipelagic country in the world, consisting of more than 17,000 islands with a very long coastline, around 81,000 kilometers, and wide area of waters. Naturally, Indonesia played a very active and important role in the negotiation leading to United Nations Convention on the Law of the Sea. Indonesia benefited greatly from the new regime, created by the convention. As provided by the convention, Indonesia has sovereign rights for the purpose of exploring and exploiting the natural resources in its exclusive economic zone. This includes the right to prohibit fishing by vessel of any other state, to arrest any foreign fishing vessel that fish in its EEZ without a permit. Here we have pictures about Indonesia archipelagic baseline that tells us the exclusive economic zones of Indonesia and the territorial waters of Indonesia, and that's the property of Indonesia. This is the archipelagic sea lanes, ASL. In Indonesian you say ALKI. So you have ASL1, ASL2, ASL3, that where others can navigate through the water. And this is also about maritime zone according to the Convention of 1982. And also this is a picture that I want you to understand this as part of the problem that we have to consider as Indonesian. Also, this is about territorial waters, Indonesia exclusive economic zones border, and this is the definition about what is meant by continental shelf, by archipelagic baseline, by archipelagic waters, territorial sea, and those kind of things. You can learn by yourself. Okay. Indonesia is recognized as an archipelagic state. As an archipelagic state, Indonesian government now exercise sovereignty over the waters between the islands making up the country's land territory, as well as over the islands themselves. For a very long time, the Java Sea and all the sea, separating the islands, separating Kalimantan from Sulawesi, were not our own, were not our property. They were high seas, so nobody claimed, ownership of that. So until mid-1950s, Indonesia's status was not an archipelagic state. So nearly all waters lying between the islands of Indonesia were as open as were the waters in the middle of the Great Ocean. So everybody can sail through the area. This changed on 13 December 1957 when the cabinet of Prime Minister Juanda Kartawijaya declared that the Indonesian government had absolute sovereignty over all the waters lying within the strait baselines drawn between the outermost island of Indonesia. These baselines, encompassing all the islands making up the country, form Indonesia into a single unified territory for the first time. That was 1957. That's why Indonesians commemorate this as a Maritime Day of Indonesia. The declaration was opposed, especially by the Western maritime powers, fearing that it had the potential to restrict the mobility of their naval forces and disrupt international shipping. Those who were concerned about the implication it might have for the free movement of ships through the archipelago and the access to fishing ground in the waters now claimed by Indonesia. In 1960, the Juanda Declaration was even enacted into national legislation. That's the law number 4, 1960. In 1982, Indonesia gained international recognition for its claim when the United Nations Convention on the Law of the Sea formally recognized the existence of new category of states known as archipelagic state, and formally declared that this state has sovereignty over their archipelagic waters. The United States refused to sign the 1982 convention, but in 1988 the superpower formally recognized the archipelagic state principle as applied by Indonesia. The diplomatic success of Indonesia of making Wawasan Nusantara recognized by the world. And the story of this successful diplomatic move by Indonesia is told by these two books, Indonesia Beyond the Water's Edge and Sovereignty and the Sea. This is book. And this is the picture about Prime Minister Juanda Kartawijaya. And this is two person who helped Juanda, campaign for that. Dr. Hasim Jalal, Indonesian diplomat, and Mohtar Mas'oed, professor of law from Pajajaran University, and later become the Minister of Foreign Affairs of Indonesia. With this, I'd like to finish our discussion about international law and its relevance to IR. I'd like you to pursue further by studying international law as part of your study of international relations. Thank you very much.